The senators who filed those motions and the amendments acted not as judges, they acted as parties. In fact, they acted as defense or counsels for the defense. They did not act in an impartial manner. Alam nyo, Christian, nakakabaliw, no? Yung nangyari, no? If it were not such a tragedy, it would have been a comedy of errors, no? At dito natin nakikita na ang mga, sadly, ang mga impeachment judges, walang trial practice. They could be judges, but, in trial practice, well, first of all, basahin natin yung rules, no? Yung rules ng House. Klarong-klaro naman na after it is convened as an impeachment court, sunod na yung reading of the articles of impeachment, no? Yun. Ang nangyari dyan, nag-file ng privilege speech, tapos nag-privilege motion, tsaka in-amend, no? Exactly the way you said it. There is no such thing first. Yung privilege motion ni Senator Judge Bato, there is no such animal as a dismissal. It is very clear in the Constitution and in the rules, it is trial. And trial means presentation of evidence. Trial will follow after the respondent, dito si Vice President Sara Duterte, ay binigyan ng pagkakataon to file her answer. Sa answer niya, yung issue na lahat na sinabi ng mga proponent ng motion at yung nag-second at yung nag-amend, lahat yan para silang nag-a-argue ng defense lawyers. In the answer, the defense lawyers, the lawyers for VP Sara Duterte, could have raised that as a defense, that the petition or the complaint for impeachment should be dismissed. Pwedeng ilagay nila yan sa answer, no? And pwedeng mag-reply kasi 10 days ang answer, after which 5 days ang reply. So, kung sa answer nila, inallege na dapat i-dismiss because of the alleged constitutional infirmities at sumagot ang prosecution, then due process would have been observed. Klaro-klaro naman sa rules. Walang animal called a dismissal. It is trial to convict or trial to acquit. In both instances, it needs trial. Yung dismissal na yan could have been part of the defense of VP Sara and her counsels in the answer and present it during the trial. Then there could be a third decision, a conviction, acquittal, or a dismissal. But this is after trial and hearing on the evidence. Ang nangyari, Christian, yung inamend nila, hindi solution yon. It is not a practical solution. It is an unconstitutional solution and an error of judgment. Whimsical. Hindi lang error of judgment. Ang pwede dyan sabihin ng mga practicing lawyers, it is whimsical, it is despotic, it is arbitrary, and it is not supported by any constitutional provision nor by their own Senate rules. Number one, yung resolution, yung amended resolution, i-remand simply to ask, did you follow your procedure? Christian, 215 signatures plus an additional 20 signatures of the House of Representatives. Isn't that a certification by the House that they have read, verified, and procedures have been followed? At saka yung sinasabi nilang there are 4 impeachment complaints, hindi totoo yan. There is only one. There is only one impeachment complaint. The earlier 3, pursuant to their rules, probably, and I don't want to second guess the House, kasi ang court, when a court receives, or when meron determination yan of substantial, whether it is in substance or in form, whether it's substantial. Ang first, alam naman natin, sinasabi ng Secretary of the House, no? The first impeachment complaint was too long. The second impeachment complaint was too short. The third complaint, when the third complaint was received, there was already a fourth impeachment complaint duly signed by 215, which rendered the giving or the transmittal of the three earlier impeachment complaints 10 days to the House and then to the Committee on Justice for the Committee on Justice to rule on. That became moot and academic because ang option na pinili ng House, which is within the rules, is a direct vote of 1/3 of the House is sufficient for the initiation of an impeachment complaint. Kasi tatlo na lagi nilang inuulit-ulit yan. There are three options. Unang-una, any private citizen, taxpayer, can file an impeachment complaint. Yun ang nangyari, no? Pero yung impeachment complaint na yan dapat certified or supported by a member of Congress. That's the first option. Yung second option, directly can be filed by a member of Congress. At ang third option, itong third option ang inadopt ng House. Yung 1/3 vote, in fact 2/3 vote sila eh. So, and all of them signed. When they signed, there is a certification that they read the complaint and that it is to their personal knowledge, they affirm the contents thereof. No, yun ang ibig sabihin ng verification. So, bakit pa i-remand? It does not need to be remanded. All it needs is a communication to the House. The Senate President, as sitting presiding judge, could have just issued a query, a Senate inquiry to the House if, in truth, the House is of the belief that there has been no violation of its own internal rules. Not only that, Christian, no? The Senate and the House are equal bodies. The House has its own rules, the Senate has its own rules. If the House is saying we are compliant with our own rules, what right does the Senate say? What right do they have to say that you did not comply with your own rules? That is within the purview of the House. And there are 215 of them plus 20 additional signatories to that impeachment complaint. So, no need to remand. Tanungin nyo lang, bakit magre-remand pa kayo? Tanungin nyo lang sa House, do you stand by your certification? Do you stand by your verification? Do you stand by your signatures that you have complied with the procedure? It is a simple letter to the House. It does not have to wait for the 20th Congress. In fact, that clearly is a violation of the continuing trial rule. Once constituted, hindi lang constituted, convened. Once convened, tuloy-tuloy dapat ang trial dyan.
Okay. Attorney Lorna, kung ang description nyo dito sa ginawa ng mga senador, whimsical, despotic, arbitrary, ano yung options na pwede to counter this brazen action by the Senate?
Well, first of all, I think it's an even impeachable offense yan, eh. But in any event, the one of the remedies, no, if you're talking about what are the legal remedies available, is first, you can go to the Supreme Court under Rule 65 of the Supreme Court for grave abuse of discretion of the Senate. Because there is nothing in the Constitution or in their rules that gives them this authority to delay any trial, reception of evidence. In fact, klarong-klaro sa rules na inapprove nila that it should be continuing trial. In fact, mali yung sinasabi nila na crossover. There is no such term as a crossover to the 20th Congress. Because once you start a trial continues until the completion of the evidence, consideration of the evidence presented, and rendition of judgment by the court. So, sabi nating mga lawyers, continuance of trial yon, hindi yung crossover. So ang remedy would be, in other words, in fact, the Senate is very concerned about due process. Due process of the accused. There also is due process of the prosecution. The prosecution here was not given any chance to speak on the issue of constitutional infirmity of the complaint that they transmitted, of the impeachment that they transmitted to the Senate. 215 signatures followed by 20 others. That's more than 2/3. That's almost majority. That's extraordinary majority of the House. Why is still there a need to remand to the House? Well, if they found a need to remand the House, it did not have to result in a delay. So now, it will now wait, by virtue of their amended resolution, it will now wait for the 20th Congress, to say whether or not they will continue with the impeachment complaint. So, isn't that a clear delay? And you have senator judges, Christian, parang ang senator judges na nag-file ng motion at nag-file ng amendment na yan, tsaka nag-file ng second of the amendment, parang sila na ang nag-act ng defense lawyers.
Precisely.
Precisely. This should have been the argument for the defense. So where is their oath of office? They just, earlier this afternoon, took an oath of office for impartial administration of justice. How is that impartial when clearly they were partial to the defense?
Attorney Lorna, may isa akong tanong dito. Bilang presiding officer, itong si Senate President Chis Escudero, dapat ba pinayagan pa niyang i-put to a vote yung motion ni Bato as amended by Cayetano kung clearly whimsical, arbitrary, despotic, unconstitutional?
The Senate President, as a presiding judge of the impeachment court, has the full authority to decide on any motion presented before it. He could have assumed that jurisdiction. He could have assumed that responsibility and say, because he is a lawyer. He understands what the Constitution is all about. He understands what the rules are all about. And he could have easily said, this is a matter for the defense to bring up in their answer. Let us wait for the parties. Let them give, and after the defense raises it in their answer, then give the prosecution the opportunity to file their own reply.